I clearly identified, the document clearly identified the trust, I could incorporate it by reference. The clear intention would be I leave everything to the trustee of the trust established, and I, on such and such a date, with so-and-so as the trustee, okay? And all that was in existence because I established this during my lifetime, and my will speaks at the time of my death. Fine, great, okay? And as long as the trust was in existence at the time I executed the will, that would be fine. But what if I want to do this? What if I incorporate this by reference, and I execute my will, and during my lifetime, I don't want to change my will. I don't want to go to that trouble, but I want to change some of the terms of my trust. Remember what the common law rule on incorporation by reference was, that that instrument had to be in existence at the time I executed my will, and it couldn't be changed after I executed my will. So I want to change some of the terms of my trust. I want to appoint a new trustee. I want to cut back on the trustee's management. I want to bring in some more beneficiaries in the trust. I can't do that and rely on common law incorporation by reference after I execute my will. I have to re-execute my will by codicil or something like that. No problem under 254.001. Right? Look at this. Look at subsection B. A device under subsection A is not invalid, that is, it's valid, because the trust is amendable, revocable, or in fact was amended after the execution of the will or after the testator's death. Wow. The common law incorporation by reference wouldn't allow that. No problem. We allow that by statute. Remember, the legislature can override the common law by statute anytime it wants to do that. Incorporation by reference is a common law doctrine, except in the case of pour-over wills to inter vivos trusts, where 254.001 overrides the common law. Okay? It broadens it. So it makes a pour-over provision, a pour-over will, validated. It allows us to change the trust even after we've executed the will. And it makes it more broadly useful. And this is a very, very useful estate planning device and a very common estate planning device. Okay, let's see. Oh, by the way, you might ask, and one more thing I'm going to ask. So suppose we have this revocable inter vivos trust, and you know what? I execute my will, and then I change my mind and I revoke the trust. I don't like it. I don't like the way I set things up in the trust. And you know what? I forget to change my will, and I die. And my will leaves everything, or my residuary estate pours it over into the revocable inter vivos trust, and that trust doesn't exist anymore because I've revoked the trust. What happens in that case? You know?
Would the courts look to your intentions and maybe look to facts of independent significance?
You think there might be something in the statute that tells us that? Look in 254.001 and see if there's anything that tells us about that. And you're right, Mr. Lincoln. We're first looking at intention. But go ahead. Look and see. Do you see a provision in there that might?
It causes the device to lapse. Section D.
Section D. Unless the testator's will provides otherwise, stop right there, right? Look to the intention of the testator, because maybe he said something different. Maybe I said something different in the will. Maybe I said what happens if I revoke the trust. But if I forget to do that in the will, then here's a default rule. And the default rule says that what happens? The revocation or termination of the trust before the testator's death causes the device to lapse. Have we seen any rules on lapsed gifts here? Sure we have. They are in section 255. The lapsed gift rules, 255.151 through .154. Remember, there's a lapse in the residuary, if there's a lapse in if it's left to two or more people. And it might be, if the will's silent and the entire residuary estate was left to the revocable inter vivos trust, and I've revoked the trust, the lapsed gift rules apply. If my will is silent, yeah, I might die intestate after all. It's going to depend, right? I really might do that. Now, there's also an anti-lapse provision. Do you remember the anti-lapse provision? No, it's been a week or two. I've forgotten it. Okay. I hope you remember it before December. I hope you remember it before the bar exam. Those of you who've taken the bar exam, because they like to test on the anti-lapse provision too. and whether it applies. What's the anti-lapse provision? I'm sorry, I've forgotten too. Someone can tell me what it is.
It's that if something is left to a particular devicee and that person predeceases the testator, then his descendants are entitled to that in equal portions.
That's right. The devicee's descendants are entitled to survive the testator, are entitled to that. If what does the devisee kind of have to do or be or something like that? There's something else important you left out.
That it's the siblings or the children of the testator's parents are not alive.
Well, okay. I mean, you're very close, right? It has to. Mr. Smith, do you remember? You're very. That's about 80% of the way.
The descendants of the parents or descendants of the
Right. So the devisee has to bear a certain relationship, blood relationship, to the testator, and they either have to be, who predeceased the testator, they either have to be the descendants of the testator or descendants of the testator's parents, right? And then they have to leave they have to leave descendants who survive the testator by more than 120 hours. You think the anti-lapse provision would apply? I don't know, but I don't think so. Why not? Would it apply to a situation that we just described in subsection D? It says revocation or termination of the trust before testator's death causes the device to collapse. You think the trust is a descendant of testator or testator's parents? I don't think so. I don't know. I mean, the court, I don't know the answer to that, because the court may look beyond that and may say, well, who were the beneficiaries of the trust? If they were the descendants of testator's parents, they might kind of collapse it and say, okay, that's close enough. We'll let the anti-lapse statute apply, and then testator won't die in testator. But I don't know the answer to that. So I'm going to ask you that. I won't ask you about that. I'm just pointing out that open question in subsection D. Okay, I think that's pretty much what I want to say about pour-over wills. Question about pour-over wills and that little pesky little problem that may cause what's poured over to lapse if testator revokes the will before testator dies. Testator's taking care of that in his will. All right, let's continue onward and upward then with incorporation by reference. And I think the next thing, we did those notes on 227, didn't we? I think we did those at the end of class. Didn't we? Was I leaping through that at the end of class last Thursday? I'm pretty sure I was. Sure, we'll say I was. Henson versus Henson, page 227. That's the next one I want to get to. What's the rule that you need to take away from this case? Anyway, what's the rule in this case? And really, it's not the holding because the court didn't really need to get to this issue. The court could have stopped short. What's the rule, or does someone want to just do the case? We can do it the old-fashioned way, and we can start at the beginning and start with the facts. But I was hoping to kind of start with the rule and work backwards a little bit. You want to do it, Mr. Johnson?
I'll take a shot.
Okay.
A fully handwritten codicil doesn't. Hold on.
You're good. Yeah.
Republish
Okay.
a typewritten will.
All right. I'm going to write this up here. A valid holographic will, or it could be, or HC, holographic codicil. All right, valid. Cannot republish or incorporate by reference a non-holographic instrument or document. And I'm going to talk about, let's talk about now what the facts of the case were. How did the court get this? So if we have a holographic will or codicil, remember we talked about the fact that a subsequent writing, a subsequent attested will can incorporate by reference something that wasn't properly executed before, or a properly attested codicil can republish under the doctrine of republication by codicil a will or an instrument that was executed before. But a holographic will or a holographic codicil can't. Why not? What happened in this case?
Is it just an unattested non-holographic instrument or document?
Well, I guess an attested one could. That's true. In theory, if it was properly attested, there were two witnesses, etc. Right? It's when I think of a holograph, you're right. You're exactly right, Mr. Beth. But if I think of a holographic will or a holographic codicil, I think of something that's been properly signed in wholly in testator's handwriting, but doesn't have the witness.
Right.
If it has the witness, it can count as attested. That's certainly true. But what happened in this case? What was it in this case? This case wasn't exactly that. The court didn't have to get this far in this case because there was an earlier instrument. What was the earlier instrument?
Typewritten will.
Okay, the earlier instrument in this case, the time one test executed, a typewritten will. Okay? So it's not wholly in testator's handwriting, we need two witnesses. How many witnesses do we have? It was notarized. We had one witness. Okay, so it was invalid because one witness only. At time two, that's time one. At time two, testator executed what?
The note on the hotel stationery that
There's a note on motel stationery, hotel stationery, right? And so there was something pre-printed on it. Does that mean it couldn't have been a valid holograph?
No.
That's a surplusage, right? Because it wasn't necessary for disposition to detect the meaning and wasn't necessary for disposition. So we could ignore that entirely. So it was wholly in testator's handwriting. What did it say? What did that
it
note?
said it was supplementary to my last will. It still stands as is.
Okay, supplement my last will, it still stands as is. And you can see everything is yours, darling, blah, blah, blah. By the way, that second instrument, so this is C executed. I'm going to say, this was invalid. I'm going to say HC, a holographic codicil. Am I right or not? What did the court?
They said it didn't have testamentary.
Okay, it was invalid because no test was not written with testamentary intent. Okay, so what we are left with is we've got a typewritten will that's invalid. You know what we call that? Piece of crap, right? Piece of crap. Okay. A holographic codicil of that typewritten will, wholly in testator's handwriting, wrote his name on it, he signed it. The court said it's invalid because there's no testamentary intent. What do we call that? Piece of crap. We have two pieces of crap that can't be offered for probate. That's it. We can all go home. The court should have gone home then. They should have shut up then. They didn't. And they said, besides, even if this were a valid holographic instrument, it can't be published by codicil, nor can it incorporate by reference something that's not wholly in testator's handwriting, because then it wouldn't be wholly in testator's handwriting. All right, that's the rule in Texas, for good or for ill. That's the rule. That's what you need to take away from this case. The court shouldn't have gotten there, because they said, actually, the court should have gotten there. I think they were wrong here. This wasn't written with testamentary intent. Come on. What did it say?
Everything is yours.
Everything is yours, darling. What
And
the
it-
hell? What
and it
the?
said how to do everything.
And that sounds to me like it's written with testamentary intent. And if the court had held that had been written with testamentary intent, then which instruments would have been admissible?
This one has testamentary intent.
Mm-hmm.
This still was said.
This one still would have been admissible because even if this one were valid as a holograph, it can't incorporate by reference or republish something that's not a holograph. It's not only in testator's handwriting.
If that first one had been attested to, you could have incorporated.
If it had been attested to, no problem, because if it had been attested to, and this had testamentary intent, what we have been left with? If this had been properly executed, we would have had a valid will. It would have been a piece of crap. And if this had been a valid holographic codicil, then it would be valid too, and it wasn't incorporated by reference. It wasn't even, was it republished even by codicil? I guess it kind of was, and I think the court's probably wrong about that. If you have a valid holographic codicil, if you have a valid attested will, both of them are admissible. I'm the court be wrong about that. I think the court went too far in this case. Okay? And I think what the court was thinking of in terms of republication by codicil is, it can't. Well, I guess it wouldn't be published by codicil. I think that would be too much. I think what the court was saying, it was thinking about Avon versus Green. Remember that case we did last week on republication by codicil, where the court said, you don't remember that, you're looking at this like, I don't know, were you here last week? I don't remember. You all remember, you in the front row remember that case, right? Avon versus Green. Look back at Avon versus Green. Talked about republication by codicil. the case that troubled us last week. Why? What were the facts of that case? I think the court would be right when it said a valid holographic will or holographic codicil can't be published by codicil. A non-holographic document is not executable. Oh, hell, I don't know. Looking back. No, it was no case was made was 2 weeks ago. The primary case. Oh, wait a second. Hell. We did it.
On 194.
194. Okay, maybe it was 2 weeks ago. I don't know. Oh, we did it on revocation. 194? No.
199, I think.
199.
Yeah.
Just for that, I think we need to give up some pizza. When we did republication by codicil, it was 199. I think it was. I think we did it maybe like Tuesday, or maybe we did it the Thursday before that. Remember that case now? What happened? We had a 1948 will, I think, and 1949 codicil. Is that right, or was it
Yeah.
49? Well, one codicil was a piece of crap because no one offered it, right? So no one offered it for the 1950 program. We did have 2 codicils. You're right. No one offered that codicil. So it was the all that was offered for probate was a 1949 duly executed attested codicil and a 1948 unexecuted instrument that purported to be a will. And the court said, you don't have to prove the due execution of the will. It was republished by codicil. And that, I said that night, I said, mark my words, we're going to get to incorporation by reference. And tonight's the night. The better theory, the better argument in that case, Avon versus Green, would have been that the 1949 codicil was really a will, and it incorporated by reference that earlier unexecuted will because they were both typewritten. Now, what if you had an unexecuted typewritten instrument, or not fully executed, not properly executed, and you had a valid holographic, what purported to be a codicil? Well, this can't incorporate by reference something that wasn't duly executed. That's what the current case tells us. The Henson versus Hinson case tells us. It can't incorporate that by reference, and it can't republish it by codicil. But I told you, I thought Avon versus Green was wrong. I think it's just wrongly decided. Because it wasn't a question of republishing by codicil. It might have been a question of incorporating by reference, but not republishing by codicil. So I think Avon versus Green was wrong. Nonetheless, I think if this had been a valid will in the Henson versus Hinson case, the case we're looking at right now, validly executed will and a validly executed holographic codicil, no problem. It would republish it by codicil because this was valid. It didn't depend on the codicil to validate the will. The will would have been validly executed, but that's not what happened in Hinson. In Hinson, the will wasn't validly executed, and the codicil, I think, was written with testamentary intent, and then the court would have had to face, if they held that, they would have had to face, well, could that republish by codicil, or could that somehow incorporate by reference something typewritten? The answer is no. Not if that wasn't validly, the first instrument wasn't validly executed itself. The court didn't have to get to that. They could have just stopped. They could have said, time number 1, typewritten will, piece of crap because it wasn't properly executed. The holographic codicil, piece of crap because it wasn't executed with testamentary intent. I think it was written with testamentary intent. But, so, I think the court got that case wrong, even though they got the reasoning wrong, even though they probably got the rule right that a holographic instrument can't incorporate by reference something that's not wholly in testator's handwriting because it's not wholly in testator's handwriting. The earlier answer. Questions? That's it. I mean, I finished my spiel on that, and I'm looking at everyone, and it's like, you don't know. I'm speaking Greek. Yes?
I don't really understand why the court said that there was no testamentary intent.
I don't understand either. I think they're wrong. Yeah,
Do they actually explicitly say, like, why they said it wasn't?
I didn't think their reasoning was very good. Let's look and see.
Well,
It says it'll stand as is.
yeah, and that
This
kind of,
supports construction.
that kills testamentary.
They thought it was a memorandum, right? My will stands as is. It's memorandum, but everything is yours, darling. I think that's testamentary intent.
Right before it says supplementary.
I know, supplementary. I know. I still think the court got the case wrong, but I understand. That's why they were saying it. Yeah, I understand. I disagree. I don't know, maybe you think the court got the case right, and that's okay. I mean, that's fine. Reason lines can differ on this one. This is kind of a hard case. I admit that. I think they got it wrong. I think supplementary my last to my last will, it still stands. I would have said that is, well, let's look at, flip back to page 227. Look at note 5. Testator's will contains the following provision. Holographic will. Handled pursuant to incomplete will Doris has. Trim versus Daniel. Remember we talked about that? That case keeps coming back. That note case keeps coming back. This could have been like Trim versus Daniel. The court could have said, supplement my last will, it still stands. Well, we don't know exactly what that is because that last will was not properly executed. This must be his will. Everything is yours, darling. It was homemade. It was holographic. They could have said that this was written in testamentary advance. They just didn't do it. I see. Some of it's contradictory, and it's just a tough case. Bad facts make bad law. All right, other questions that I will probably duck or just say bad facts make bad law. I don't know. I can't have a good explanation for this. All right, let's look at the notes on page 232 afterwards. Upon testator's death, a valid will and an invalid codicil thereto are found. Okay? Which documents may be admitted to probate? Does the attested holographic nature of the documents make any difference to the result? You know, I don't know. Is this a trick question? Is this just a tautology? If the will is valid, I think it's admissible to probate, regardless of whether the holograph is attested or not attested. Whether it's, the subsequent, whether it's holographic or not, I don't think that matters. And if the codicil is invalid for whatever reason, I don't think it's admissible to probate. I think the will is just admitted to probate. I'd have to know more facts. It might depend, but I can't see it. I mean, what do we call that second invalid subsequent instrument? That's right, it's a piece of crap. It's as if it never existed. So I don't see that we can even look at it. I don't see why you wouldn't go ahead and, or the court wouldn't go ahead and admit the valid will. How do we know the will is valid? Because Professor Meyer tells us that. Just like on the final exam, if I tell you something's valid, don't argue with me. I'm not going to argue with you. So I'm not really sure what his point was there. And I'll stop if you all read that question differently than I do. I'm just not sure what the point of that question is. I mean, thoughts? Okay. I mean, it seems pretty obvious to me. Now, how about number 2? Upon testator's death, an invalid will, and a valid attested codicil to that will are found. Which documents may be admitted to probate? Blah, blah, blah. If the invalid will is attested or is holographic. All right, there's a valid attested codicil, and if the invalid will, piece of crap, right, was attested, but something was wrong with it for whatever reason, but there was a codicil. Could we admit the codicil and the will? If so, under what theory? Valid attested codicil. In theory, that ought to be admissible. Invalid will. It shouldn't be admissible on its own. Under what theory? 2A, both are attested. Okay? Well, right, the invalid will is attested, and the valid codicil is attested. If I think the invalid will is attested and the valid codicil is attested, I think both of them are admissible. And what might be my authority? How about republication by codicil? How about Avon versus Green? That's pretty close to the facts of Avon versus Green, which I think is wrong, but we're stuck with it. Okay? How about incorporation by reference? The codicil is invalid, but the attested will is, the codicil is valid. The attested codicil is valid. The will is invalid. No problem. If the codicil expressly refers to the will and says this is the codicil of that will, it clearly identifies it. It shows ineffectively a practical effect and intention to incorporate it, and we know it was in existence because it was executed subsequently. I think we can incorporate it by reference. Here's the harder question. How about 2B? What if the invalid will is holographic and the attested codicil subsequent document is not holographic, it's typewritten but properly attested? Could that incorporate by reference an earlier invalid holographic will that say testator wrote things out but didn't sign it, let's say it's invalid? Could an attested codicil incorporate by reference an earlier holographic document? Sure it can. Why? How's that different than Henson versus Henson? It's the opposite of Henson versus Henson, right? The subsequent holographic instrument can incorporate by reference something that was written prior in time that wasn't wholly in testator's handwriting. The other way around doesn't matter, right? If the later thing was properly attested, it can incorporate by reference anything, wholly testator's handwriting or not, because it's the later thing that's properly executed. The whole point of incorporation by reference is the earlier document doesn't have to be duly executed, as long as the later document is. The later document is, it incorporates the earlier document with one exception, Henson versus Henson. If that later document is a holograph, it can't incorporate anything else that's not wholly in testator's handwriting. That's the one little exception.
So if the later document is,
Easy, simple, straightforward. You'd have to be a moron not to get this stuff, right? I know, it's so hard. I'm sorry. This is so hard. I wish this were easy. I'm going to get back to you. I lied. Remember I said, did I say it backwards? Did I say that backwards? Did I say it? Please tell me if I said it
I
backwards.
have no idea.
You have no idea. Okay, good. Then my job is done here. This is great. I'm sorry, if the invalid will is a holograph, okay, but I was changing the facts of the note, right? Note 2A. Let me go back, Mr. Johnstone. Let's go back and do this and make sure I said it right. 2A. The invalid will was attested, but it was invalid for some other reason, whatever reason. But there's a valid attested codicil to the will. That can, A1 versus Green, republish it. I think that's wrong, but it certainly can incorporate it by reference. No problem, because nothing's a holograph, right? 2A. They're both attested. It can incorporate it by reference. If the codicil properly refers to the will, and so it's clearly identified, arguably there's an intention to incorporate it because it's a codicil to a will, and it's in existence. We know by definition it's a codicil, so it's executed subsequently. It can incorporate it by reference. 2A. Question about that?
What if it's not attested? Does that make a difference?
What if what wasn't attested?
The invalid will?
The invalid. So do your answers depend on the reason the will was invalid? I don't think so. I really don't think so. And I'll tell you why not. I think Professor Byer might think the answer is yes. I think so. So what if, for example, it's invalid because there were no witnesses? Well, if it's attested, then it seems like there must be witnesses, but maybe there weren't. If there's undue influence, lack of testamentary capacity, I don't think so, because the valid attested codicil can incorporate anything by reference. It doesn't have to be valid. That's the whole point. The problem that's tricking you all up, and problem 2, is the earlier thing is a will. No, it's a piece of crap. It's invalid. It's forget the will. Take the word will out. And I know I'm throwing that word around a lot, and people don't like it. But I'm making a point here. If I call it a will and it's invalid, it's not a will. It's a piece of crap. Can't be admitted to probate on its own, but it could be admitted to probate if it's incorporated by reference into something else that was properly executed. And that's what 2A tells us. That's the exact facts of 2A. So I don't think it matters. I think Byer might think it matters, because I think that's why he raised that question. I don't think it matters if there was an intention to incorporate it by reference. That's 2A. Now, 2B, or not 2B, that is the question. 2B tells us we have a valid attested codicil, valid, okay, properly executed, valid. 2A, it's an invalid will that was a holograph. Invalid will, remember what we call that, piece of crap. So a subsequent duly attested instrument can incorporate by reference anything that's in existence, clearly identified, and is intended to be incorporated by reference. Whether it's in writing, in handwriting or not, doesn't matter. Henson versus Henson, the problem was it was the other way around. Okay, what? So yes, I think both would be admissible in 2A and in 2B. That's what I believe. Yes, now. Does that help? Does that help me? No, it's still okay. All right.
2A, you said it could be incorporated by reference. Do you you also say it could be republished by copy?
Yeah, I think it could be republished by codicil, because I think that's an awful lot like the facts of Avon versus Green. I think that was a wrongly decided case, but in 2A, I think that was an awful lot like Avon versus Green, where you had this subsequent codicil that was duly executed, and the will, all they had was a copy of an unexecuted will, and there was no problem, it was republished by codicil. No, I think it was incorporated by reference. That's 2A, but 2A is close to the facts of Avon versus Green. I don't agree, but that's what the court said, republished by codicil. Okay. So did I say that it could be republished by codicil? No, but that's what the court said in Avon versus Green, so I have to say it too. Okay? Now,
So-
how do I even phrase a question like that? Alton's on a real roll tonight. I don't know where he's going.
So
He doesn't either. Fast
the
food
later
sequence, so you're
document,
fucking
which
right.
is the later document, which is referred to as a codicil in 2A and B, successfully incorporates the prior document, with whatever it's
By
called.
reference, absolutely.
It's no longer considered a codicil, and it would now be considered
It's
the will.
basically the will.
Okay.
It's basically the will.
Okay.
That's right. Yeah, it's basically the will. Well, how could it be? It's just supplementing. No, it's incorporating by reference. Now all of that's the will. You're exactly right. It's basically the will, right? So that thing that's identified as a codicil, if the earlier thing is invalid, the earlier will's invalid, it's a piece of crap. So the codicil is actually the will if it incorporates that, the earlier thing. Yes. Okay,
And then
now,
to follow up, let's say in a will you have 10 different items being disposed of, and the codicil is modifying one.
modifying one.
One.
Well,
Okay, so a codicil doesn't have to redo the
you
entire
don't
will.
have to redo the entire will.
So I'm making a modification to item number 1, and there's 9 following.
Mhm.
So if you're incorporating by reference,
You have to see the language of the codicil, but generally, well-drafted codicils will say, I make this one change to my will, except as expressly modified herein, my will still stands. Now you've just incorporated by reference, haven't you? And the will, it's not that the will stands, it's now been incorporated by reference. That's what I think.
the rest of the
The rest of everything else. But
Okay.
yeah, that's what I think. I could, as I say, I often say this, I could be wrong, but I'm grading your exam. So it comes up on the exam, just take it down. You can argue with me later, and this is the beauty of all this.
I'm just trying to
This-
understand.
This is the beauty of all this. When you get out into practice, you get the facts of Avon versus Green. I think it's wrong. You'll make your best argument against it. You might win. You'll make your best argument against what, if it's not clear what I say, or what I say may be clear, and you say, okay, I disagree with you, Alton, but if that's what you say and it comes up on the exam, that's what I'm going to give you. That's right. That's what you do need to give me. When you get out in real life, the law changes. Statutes change. Court decisions change it. And interpretations change. And I could be wrong. I fully admit that. Okay? But I am better. So, all right. Yes.
But as you said, it depends on how the codicil is written.
It might depend on how the codicil, yes.
Okay.
I'm just blithely assuming that the codicil contains language that would make it clear enough that you're referring to the will, and in some way a court would infer that there was an intention to incorporate that. Clearly it would have been in existence. Clearly it would have identified the will. It doesn't identify the will and doesn't somehow tie back into it, so there seems to be an arguable intention to incorporate it. Well, I guess the answer would be no. So your answer really might be that it depends. If something like this comes up on the final exam, I can't remember when it does. Stop looking at the clock. That clock's not moving. Time has stood still as I told my day class. This is kind of like a Twilight Zone episode, right? Where time just stands still. We're never going to get out of this. The Hotel California, right? You can check out any time, but you can never leave. But that's false imprisonment, isn't it? Okay. Yeah, I'm keeping track. We got 30 minutes, I promise. I would never give you a problem like problem 2 on page 232. I would give you more facts. I would say the subsequent document says this, so that it would be clear that, oh no, it's not clearly identified, there's no intention, or it is clearly identified and there is intention. I would make it clear. I don't like these kinds of very general questions. Okay. Other questions that I don't want to answer? Yes, if it's off. That's right, yes.
So, this rule from Henson, would it matter if the will is already valid, the non-holographic?
Yeah, valid holographic will or codicil not in published and incorporated non-holographic. That's a prior instrument, right? So if the prior instrument was valid, then it's not a question of incorporating by reference. It's just a question of you've got a will and you've got a codicil. Then it's not a piece of crap if it's valid, but if it's validly executed as a will, but it's validly executed. The problem in Hinton was the earlier thing wasn't valid. That's it. What I think keeps throwing everyone is they say, what about that earlier will? Now, what about that earlier piece of crap? If it's invalid, it's a piece of crap. Don't call it a will. I mean, I know, I'm sorry, you don't like me cursing. I could have used a different four-letter word that means crap, that would offend a lot more people than the word crap. But the point of junk, how about that? Is that better? Okay? It's a piece of junk. Don't call it a will. That's what throws you off. Okay? If it's invalid, then it can't stand on its own. It might be incorporated by reference if everything's right. If the subsequent instrument's a holograph, Hinton tells us it can't incorporate that earlier invalid typewritten crap. But if the earlier thing is valid, then we don't need to rely on incorporation by reference if they're both valid, right?
What about republication?
Yeah, if they're both valid, there's no problem with republication by codicil either. It's treated as being re-executed. Oh, a subsequent instrument can't, subsequent holograph that's valid can't republish by codicil something that was not only in testator's handwriting. If they're both validly executed, it can. Yeah, I think the Hinton court was wrong in that statement.
You think
Go ahead.
with the rule just saying a valid holographic will or codicil cannot incorporate or republish a non-attested non-holographic instrument?
A non-attested, non-holographic instrument. Yeah, that's probably better. Say that again, Mr. Brown.
Just add the word non-attested there before non-holographic.
A non-attested, non-holographic. Okay. See, that's very better. See, that's any better. Non-attested. Or otherwise invalid. How about that? Or otherwise invalid, right? Because maybe it didn't have, wasn't, it was duly executed, but it didn't have definite capacity or something like that. I think that'll work. Okay, that's an improvement on what I said, and maybe on what the court said. Okay, because that's what was going on. That's what it was talking about in that case. Don't get so hung up on this case. I can't remember the last time I've asked a question about it on the final exam. So that when I said to you, if I ask a question about it on the final exam, just take my word for it. I don't recall asking a question about it. Okay? It could come up, but I kind of doubt it will. Incorporation by reference will come up. I promise. Okay? And we're not finished with incorporation by reference. We've got a lot more to do on incorporation by reference, and we're going to do it right now. Oh, no, we don't. We're not finished with it because we're jumping on to, the other notes here, skip them. I'm out of time. Facts of independent significance, page 232. We're not finished with incorporation by reference. We're going to come back and work some problems and hypos after we do the facts of independent significance case, where incorporation by reference will be an alternative theory. Okay? Let me distinguish facts of independent significance from incorporation by reference. Under incorporation by reference, we know if there's an extrinsic writing, a document, instrument, that's not itself admissible because it wasn't duly executed, it still could, if it was in existence, there was a clear intention to incorporate it by reference, and a subsequent instrument is validly executed and clearly identifies that earlier document, it can be incorporated by reference. As part of it. That's just the holographic, the subsequent one is a holograph, and the earlier one's not a holograph. All right. Facts of independent significance are different. If the facts of independent significance requirement, that doctrine, those elements are met, then that extrinsic writing, that document, or maybe it's not even a document, maybe it's nothing in writing, maybe it's an act of some kind. It's not even in writing. And it might not even be in existence at the time the will is executed, which incorporation by reference requires, except for Toro, which right, is a statute. That thing could determine a disposition under a will. Did I repeat that? No, I can't. Did I explain that? No, I can't, because there's cases and problems on it right now, and it's going to become clear, I hope. And if it isn't, then I am going to repeat it. Oh, you're thinking. I know exactly what you're thinking. Why will those hands never move? But you ever went, how many people are keeping track of time? Oh, you don't want to admit it, right? Yeah, okay. Half of you and the other half don't want to admit it. That's okay. I'm keeping track of time too. That's fine. All right. In the Welch case, page 232. What happened? What was the incorporation by reference or facts of independent significance from in that case?
Oh, I mean, so Sarah Linda Welch, she was a resident of South Carolina, had some property in Texas, some oil fields, and she set up in her will that her that property, which is a lot of money, would go into a charitable trust that her brother had set up. However, so she predeceased her brother, but as I understand it, the trust had changed.
Okay.
And it's at that time it was called the Robert A. Welch Foundation,
Okay.
and the court had motions for rehearing, and the issue was what was her intention for where the funds should go, and the fact of independent significance was her intention to send it to a charitable foundation.
Okay, I think you're pretty. I think you're accurate. Basically, I think a couple of facts are wrong, as I recall the facts, and maybe I'm wrong about this. She basically, let me simplify some of what you said. If that's okay. If it's not, let me simplify it. I know you're kind enough to let me do that, which I appreciate. She had a will, and she left her entire residuary estate. She poured it over not into her own trust, but into someone else's trust, her brother's trust, that was going to be set up. He had set up, if he predeceased her, leaving a will that established a charitable trust. At the time she executed her will, they were both still alive. Do you think it's surprising that she was still alive when she executed her will? No, but he was still alive when she executed her will, right? So she was alive, she executes her will, and she said, I'm leaving everything to my brother's charitable trust that he sets up in his will. Well, he's not dead yet, so his will isn't effective yet, okay? But in fact, it did happen. He did predecease her. And so, in fact, she died. He had died first. He had set up a charitable trust in his will, a charitable foundation or trust. I can't remember which it was. I think it was a trust in his will. And so her will was going to pour over her entire estate into his charitable trust. Now, who was upset about this? If her will was invalid, her entire residuary estate was going to a charitable trust. If her will was invalid, what would happen?
It would go in intestate.
It would go intestate. That's right. It would lapse. The whole residuary would have lapsed. It would go intestate. So who was
The foundation.
Who's contesting this will?
The foundation.
The foundation wanted the will to be good. Who was contesting it?
Or
Her heirs, of
yeah,
course.
her heirs,
That's
yeah.
right. Oh, no. She was, my third cousin 4 times removed, or my dear old auntie or great aunt or something like that. This was invalid. We know what she wanted, but she can't have what she wants. Chuck E. Cheese or something like that, right? She can't have what she wants. Sadly, we'll have to take everything because we're her heirs at law. That's what we want. The court on rehearing, this is the Court of Appeals, and they had, you see, they talked about the facts, and on 234 they talk about their on motion for rehearing. They upheld the validity of her will, not on an incorporation by reference theory, because there was no indication, there's no incorporation by reference here, because there was no indication that at the time she wrote her will, his trust certain hadn't been established, and there was no indication, I think, that had he written his will? I don't think he had written his will. Or it had changed or something like that. So there was a problem with incorporation by reference, but there was no problem with facts of independent significance. What's the doctrine? What's the rule? Bottom of page 234, quoting at length from Scott on trusts. What's the rule?
Even though disposition cannot be fully ascertained.
Let me stop you and make sure everyone can hear you back in the back. That's it. That's exactly right. Can I get you to speak up a little bit, please?
Yes. Even though a disposition cannot be fully ascertained from the terms of the will.
That's her will, right?
Yes.
Her will. Then go ahead.
It is not invalid if it can be ascertained from facts which have significance apart from their effect upon the disposition in the will.
It is frequently necessary to resort to extrinsic evidence to identify the persons who are to take for the subject matter of a disposition. So that's it. That's the indeed is the addition, but your 2 sentences are the rule. Okay? It's not invalid to be ascertained from facts that have significance. Well, I guess your 1 sentence. Okay? Facts which have significance apart from their effect upon the disposition in the will. What the hell does that mean? How about this? The Uniform Probate Code has a rule on facts of independent significance, and I want you just to listen first, and then I'll let you take it down if you want to take it down. Okay? Here it is, because it's like 3 or 4 lines long. Just listen, don't try to take it down. A will may dispose of property by reference to acts and events that have significance. They're outside the will. Extrinsic acts or events outside the will that have significance apart from their effect upon the dispositions made by the will, whether they occur before or after the execution of the will, or before or even after testator's death. Okay. I mean, read that one again? Okay, here we go. Because I think this is better, but maybe it's not better. I don't know. Ms. Remper, I'm going to come back and ask you if you think this is a better iteration of this one probate. It may not be better. I don't know. Maybe we'll see. All right, ready? Get ready to write. A will may dispose of property. A will may dispose of property by reference to acts and events. A will may dispose of property by reference to acts and events that have significance apart from, that's CE, not TS. They have significance apart from their effect, as the acts and events effect, from their effect upon the dispositions made by the will. They have significance apart from their effect upon the dispositions made by the will, comma, whether they occur before or after, the execution of the will, whether they occur before or after the execution of the will, or before or after testator's death, period. Or before or after testator's death. Is that better than what Scott said, or is it worse? Think about what's going on here. Think about what's going on in the Welsh case, right? She says, I'm leaving everything to any charitable trust that my brother establishes in his will. There's no evidence that he had already executed his will. I guess we could see the dates, but it doesn't matter under facts of independent significance. As long as those other facts, or those other events, or those other happenings, or those other writings, whatever they are done with some motive apart from the effect that they'll have on disposing of her estate. Done with some motive apart from the effect they'll have on her will, on her estate. Then her estate can do that. Her will can do that, and it's valid. So, there has to be some independent motivation outside her will, beyond the death time motivation, for that other fact or action or writing to occur. So what is, in the Welsh case, what's the independent motivation? Not what she did. She left it to her brother's to her brother's trust. What's the independent motivation for her brother setting up a testamentary trust? Did he do it for the purpose of passing her property? Why did he set up the testamentary trust, a trust from his will? That's what he wanted. It passed his property. So there's a motivation apart from the effect it was going to have on her estate. As long as there's a motivation apart from the effect that it has on her estate, it's valid. Now, I'm going to tell you this. This is one of the hardest examples of facts of independent significance. And I hate this when casebook writers do this, right? So they do this all the time. And this casebook's, I think, a wonderful little casebook. And generally, I like the cases that are in it. But sometimes, and you think back particularly, this happens in the first year, you've got this big case and you read it, and then note 1 says, the case represents the exception. The general rule is, well, okay, this is an exceptional kind of situation. It does come up. This is perfectly fine. That's not the best example of facts of independent significance. So, I can give you some examples. Bottom of page 234 of the casebook. Scott gives us some examples right after that. Thus, a bequest to the children or the heirs or next of kin of a named person requires a resort to extrinsic evidence to establish their identity. But it is, of course, valid. I leave everything to my heirs. I leave everything to my children. Well, we have to go outside the will, if those people aren't named on the face of my will, to see who those people are. But it's valid. The facts of independent significance, those external events, those external people, those external documents, whatever, the effects that they have on my will are valid as long as there's some lifetime motivation for me having, or beyond death time motivation for me having children or heirs of these other people. Yeah, they exist on their own. We didn't just have them so that I could pass stuff to them in my will. Right? They're out there on their own. Let me give you a couple other examples of this. suppose the testator's will leaves the automobile that I own at my death to A. The automobile that I own at my death to A. At the time testator executes her will, she owns an old, beaten up, broken down Ford. But shortly thereafter, she gives it to, who will haul it off? PBS. KERA will haul off that lemon for her, hauls it off, and she buys a brand new, shiny Cadillac. Okay. Is that bequest valid? Does A take, and then she dies, she's so happy, she dies. Does A take the car, the automobile that I own at my death, which is a Cadillac? Of course, we resort to extrinsic evidence. We see that the Cadillac is the car that testator owned at her death, and A takes that car. No problem, because testator didn't buy the car with the sole purpose in mind of changing what she was going to give to A under her will. Why did she buy the Cadillac? She wanted to drive it. Okay, that's great. There's motivation apart from the death time motivation from passing it. What if she's old and senile and can't see and can't drive anymore? Can you think of a possible lifetime motivation for her buying the Cadillac? When you think of any lifetime motivation for her getting into the Ford and buying the Cadillac, that's good enough. In fact, what?
She wanted a car to ride around.
She wanted a car to ride around in. Someone else would drive it. What if she never put any gas in it? And she just parked it in front. Maybe she wanted the pride of showing off to her neighbors that during her lifetime she could afford a Cadillac. It's all good enough. You wouldn't question that, right? I mean, that all makes perfect sense, doesn't it? The Welsh case is kind of an exceptional case. I mean, it's harder facts. I fully admit that. How about this one? This is common. And this is kind of like bottom page 234, top of 235. This is similar to what the example Scott gives. Suppose testator says in her will, I give $1,000 to each person who shall be in my employment at the time of my death. And at the time, it's me. Okay. Or let's just say I give $1,000 to everyone who is in my wills and estates class at the time of my death. Okay. Right now, it's you. But you know, I survive till next year, and then I drop dead in the middle of when I'm teaching class next fall, and it's an entirely different class. Is that valid? Do they take or did you take? Right? It's an entirely different class from the class that was alive, that was here in place when I executed my will. Well, of course, the next people take. You take extrinsic evidence to see who that is at the time of my death. And is there any kind of lifetime motivation for them or me having a different class next year? Yeah, because you've already taken, you've already graduated, or you've already finished the class successfully. Or if you're lucky, and that's my will, you fail the class, you've taken it again, and you get the $1,000. But no, we're not going to assume that that's going to happen again, right? There's some independent lifetime motivation for me or the members of the class not being in the class anymore, other than the effect that it would have on changing who the beneficiaries of my will are. Right? You see that? Better A or B? Or C? Or D or F for that matter? I don't know. How about, yes, as a practical matter, these facts of independent significance are going to have an effect on how testator's property passes at death, to whom it passes, or what's passed. Okay? But the whole point of the change in the class, or the change in who's employed by me, or the change in the kind of car I have, its sole purpose is not to change not to change the disposition of my property. There's at least one other lifetime motivation that I might have had. Now, students ask me all the time, does the testator have to have that lifetime motivation in mind? No. Who's going to have that lifetime motivation in mind? The court, looking at it after testator's dead, when there's been a challenge to the will, the court's going to say, well, could testator have had a lifetime motivation, or could those other people have a lifetime motivation? Could those events have happened for even one other purpose that we can think of, apart from the effect they're going to have on passing testator's property after his death? The answer is yes. Then facts of independent significance apply. It's very common. Look at the notes afterwards, 236. What is a fact of independent significance, and what important is the determination that something is a fact of independent significance? I think we've beaten that one up as much as we possibly can, but not quite, because we're going to have some hypos on this. in a moment, I hope. Note 2, how would the Welch case be decided under States Code 254.001? Remember, 254.001 allowed pour-over wills into a revocable under vivos trust as testator established during testator's lifetime. Look at this. A testator may validly devise property in a will to the trustee of the trust established or to be established. 1, 254.001. This is what I'm reading with that here. During testator's lifetime by the testator, another person, or another person. ... Or 2, at testator's death by the testator's device to a trustee, regardless of the existence, size, or character of the corpus. This is easy. This perfectly validates what happened in the Welch case. The Welch case was in effect a pour-over will, but into someone else's trust, not testator's own trust. Was that in existence at the time of the will? If it wasn't in existence, it couldn't be incorporated by reference. No problem. We don't have a problem. The statute validates that. We don't have to say it's incorporated by reference or facts of independent significance. It's valid under the statute. We don't have to resort to those kinds of common law doctrines anymore. Number 2. Number 3, page 236. Testator's will contains the following provision. I leave the contents of my safe deposit box, 127C, at Octopus National Bank to Bob. When the will was executed, the box contained $50 in cash. Upon testator's death, the box contains $1,000 in cash. How much is Bob entitled to? How much is Bob entitled to? $10,000. Why? Facts of independent significance. Why? What if we showed the testator augmented that $50 by $9,950? Testator was the one who put the other money into it to bring it up to $10,000, and Bob is going to take $10,000. That has an effect on his testamentary disposition, right? But that's facts of independent significance say that's valid if we can think of one possible lifetime motivation apart from the will for testator putting that money, or someone else for that matter, who has access to the box, but let's say testator, make it hard, putting that money in the safe deposit box. What is it? What's the lifetime motivation? Didn't want it stolen. Safekeeping, exactly right. Safekeeping, there's your lifetime motivation. Facts of independent significance say that's valid. Wow! How about if we're the other way around? What if there were $10,000 in there when testator executed his will, and we go in there and there's only $50? Same thing. Exactly right. Now, you see the possible, the question about fraud? What if testator and someone else, maybe testator's heir who wasn't Bob, had access to that safe deposit box and went in and there was $10,000 there? What is $10,000 there? I know that my dear old auntie, of whom I am the sole heir, has $10,000 in here and has a will leaving her the contents to Bob. No one will miss $9,950, will they? How would you prove that? Right? It'd be hard to prove. Okay? Facts of independence. All right. How about number 4? Testator's will. Valid will. It's not a piece of crap. It's a valid will. What he tells you about says, I leave my personal property to those persons I shall name on a piece of paper to be found in my top desk drawer. Upon testator's death, an unsigned handwritten note is found in the top drawer, which lists various items of personal property along with their intended recipients. Will the property be distributed according to the note? Wait for a second to see what would happen if the note were signed. I leave this on those persons I shall name on a piece of paper to be found. Incorporation by reference. I shall name on a piece of paper. Incorporation by reference. I'll tell you what. Let's make it easier. That subsequent note isn't signed, but it's dated. And it's dated 3 days after the will. Incorporation by reference? No, because it wasn't in existence at the time the will was executed. So stop right there. Can't be incorporated by reference. Facts of independent significance. There's got to be an independent lifetime motivation. This can't be, the death time motivation can't be the only reason the testator is doing this. Otherwise, we would say, testator, execute the damn piece of paper. And then it can be admitted to probate. It can be valid. This isn't signed. Okay? So, facts of independent significance. It's in her desk. Okay, it's found in the top drawer of her desk. What if it's locked? What if her desk is locked and she's the only one that has the key? What if it's found in her safe deposit box? I still don't think facts of independent significance apply. Why not? Because what?
Because there wasn't for another purpose.
I don't see the lifetime motivation. Safekeeping what? This piece of paper isn't valuable in and of itself. It's only valuable as a testamentary instrument, and it wasn't executed. I don't see it. I don't think this one can be admitted under facts of independent significance. How about, it says, what if the note were signed? What if the note were signed by testator? Wholly in testator's handwriting and the note were signed by testator. Then what? Sure, it's admissible. Why? Under what doctrine? It's a valid holographic codicil, of course. He signed it. Wholly in her handwriting, she signed it. Fine, it's a holographic codicil. That's not a problem. But it's not facts of independent significance because it has no independent lifetime motivation. It has a death time motivation. Death time motivation only. Okay. So let me do this. Let's see. And I'm just about out of time here. So my hypo says, let's change the facts a bit. And this is so important because I often ask a question about this on the final exam, but I can't keep you for this now. So this is where we'll start next time. And we're going to kind of pull together. I'm going to give a hypo that's going to allow you to pull together a lot of this stuff and compare and contrast some of these doctrines. I hope. We'll see. That's my goal. Anyway. All right. See you next time. And the second row is on call. Yes. Sure. Yes. No, it's valid holographic codicil.
Oh, okay.
I'm sorry. Valid holographic codicil. Yes, ma'am.
How is this doctor from like case right now?
Well, it is different. I'm going to tell you in a moment. But I can see why you think so. We have to get extrinsic evidence in all those cases. There are ambiguity to see what, I was just on my children, they had everything. Look outside the will. I was going to ask you, is that an ambiguity? No, children, we're not sure who they are. We have to look outside to get it. We have to make sure we have to do that to protect that. So I can see why. That might be confusing. I was thinking about this today as I was reading.
The reason I did that is because
Well, that's not a mistake. You have to find look at it like
and then
just find out. No, it's just that if you have children who are working legal money, he had children who were lifetime motivation, and he just happens without naming children.
It's not great.
It's one of those things that most 90% of that doctor the house that I own, my dad, my grandmother's ring. We don't,
So,
my diamond ring. There more than one diamond ring.
you just called charter?
Yeah. But it depends where you live. Like, obviously, each neighborhood is different.
Yeah.
I want to say anything different. Like, tax found that for Time Warner is cheaper for me than like, I didn't call them. I never knew to get calling.
Oh.
It didn't happen in my area. Or in my district. Like, I'm going to figure that address.
Thank you. That's a good question.
Okay, so Time Warner is cheaper?
It's cheaper. You don't always know.
Yeah.
Their whole thing, so they,
We'll start.
it might be the one.
And then there's an installation charge as well, right? There is?
I don't know.
Note 4 on page 236.
Clear was so. Yeah. Those are interesting socks.
so thank you. Like that police officer.
Nice.
See
Well,
you later.
so I guess I'll call Charter and Time Warner.
I was going to say, you can probably look online.
Yeah, I went online. I think Charter definitely reaches me. I don't remember Time Warner. I was doing research trying to find another 4G that was like, those things don't exist anymore.
Yeah, I'm getting rid of that. We're phasing it out.
And they do.
Yeah. Oh well, this is life. Oh, I got it. Okay.